I'm not saying that I'm trying to remove her. I'm just trying to ask you, please, forgive me for having to ask you for this. If you could please let her know, please, to just be nice to me and have a welcoming attitude, and things will probably change, and I will not get up and I walk out.
All right, a dramatic reading of Sarah Boone's 58-page letter. Jesus Christ. Honorable Judge Kraynick, ongoing 5 years. Why can't I use my constitutional rights? Am I the only one who cares about the ongoing violations of? Why can't I have a bond? Why can't I have my medical records? Why can't I have all my digital evidence and discovery? Why can't I have my paperwork, notes, letters, pictures, everything of mine returned by former attorneys? Why can't I speak to my investigator? Why can't I have complete download of my phone? Why can't I have any of my witness list? Why can't I give any insight, understanding, clarifications, truths about my case, especially to my attorney? Why can't I be listened to by anyone, especially my attorney? Why can't I be respected for who I am truly, especially by my attorney, and not be disrespected for the mutilated, malicious murderer all the world has falsely, incorrectly created and believes me to be? Why can't I be treated fairly, lawfully, and be protected by the justice system? Why can't I properly, rightfully, completely defend myself? Why can't I see all and know the same as the world can and does, including my attorney? From all the phenomenal, non-permissive amount of my entire case being available online globally before my trial, and most important, before I have seen myself. What doesn't anyone know already about my case? How about my side and everything about everything? Why can't I be correctly understood that I am not the problem for reasons I am not malappointed by court attorneys? See my letter 7/21/23. Why can I say what I want and should, but all the world can and say it all wrong and warped? Why won't my attorney give me an honest answer? Why won't my attorney show me everything she says she has and finish reviewing for my case, but withheld from me after I asked repeatedly for and about? Why won't my attorney give me an answer other than, I'm putting this to rest? That's not necessary, and I'm not having this conversation with you. Why won't my attorney grant me access to anything I ask for in and about my case? Why won't my attorney, like the detectives in my case, stop putting words in my mouth?
But not intentional. My intention was not, I didn't do it intentionally. That was not my intention. But my intention was not for this to happen. It was not intentional. It was not intentional. Not intentional. I didn't intentionally know that it was not in any way, shape, or form. Hand on the Bible, intentional. No, intentionally. I didn't intentionally, but I intentionally didn't do it. That I intentionally did not do. Not intentionally. Not intentionally. Not intentionally. I didn't do that intentionally. Did not intentionally, but I did that intentionally. You think that I did that intentionally. So not intentionally to leave him there. Or intentional. In no way, shape, or form was it intentional. It was not intentional. Not intentional. Being intentional is not my intent. It was not intentional. It was not intentional. It was not intentional. That was not my intent. Not my intention. What, that it wasn't intentional? Yes, but it was not intentional. Not intentionally. Intentionally. Not intentional. This was not my intention. Unintentionally.
Why won't my attorney tell me what's going on in my case? It's been well over 100 days. She's been my attorney, and I still do not know. Ongoing 5 years. Why won't my attorney answer any of my questions? Why won't my attorney ever ask me any questions? How can she supposedly know everything she needs to know from what she's been told, heard, read, seen? Why won't my attorney reassure they're on my side, for me, not against? Why have I already been judged in the court of public opinion? How did that happen? Why have I been sentenced by anticipation and condemned before my predicted trial? Why does my attorney and all the world think my case is already over? Your Honor, during our first introduction at my last withdrawal of court appointed attorney number 7, Hobson, you stated to me your uninvolvement with any of my letters I write. I am still going to write my letters as conduitely they are to the world where all my potential jurors are located. And this is the only way anyone, including yourself, knows the very necessary insight to my continued disadvantages, hindrances, impediments, and I am still experiencing on top of the new spurring my intentions to write. The race to the pulpit is unfair, and it is important to me that you are aware and understand what transpires when the news cameras are off and we're all in between my status hearings. Two, as so many of the disadvantage, the Two, as so many of the advantageous embezzlers, racketeers, mindless leanings, and just altogether mean people can use their freedom of speech, not knowing me in any way other than what's being said by all the other mean people and being said incredibly incorrectly, so can't I? As the compelling, annoying detectives in my case, the woman had to falsify documents, and the man wore his gun for me to see. I am sure you are familiar with, after watching all my plastered, highly misconstrued, over 30 plus million views just on one site, interviews, and in which they both repeatedly attempted to feed me their incorrect, incomplete, hypothesized opinion by stating to me, everyone has their limits. At this seemingly endless point of perpetuity of nonsense and lawlessness still growing, and I am very much want to advance in the next level after ongoing 5 years now. A genuine concerned limit has been reached. Why am I still not being included in my case? How much more of my case and self is being added hourly, especially after this letter gets loose, to the internet, increasing the mass infection and destruction of my hopes to have a fair trial? Anything fair, my side foremost, and wondering now if my attorneys drank the punch like everyone else. All aforementioned reasons and so many more for this letter to be written, hoping to deter some of the unfair, one-sided finger pointing of corruption and malpractice being directed at me only by those in the justice system who are trying to deflect the shame and shock from me fearlessly challenging the status quo. And it must be so because it's in my face on the computer at the same time on my boob tube television, brainwashed, ignorant followers of disbelief, conformity, and greed, trying unsuccessfully to make my life by character assassination seem worse than theirs. No, two, when anyone points their finger, one, it's impolite, and two, three point back at you. How many try to see it? Put the stone down, as there will be no casting of anything today, except maybe for the role of my part for all the pre-conclusion documentaries and crystal ball real life stories of true crime and incorrectly formulated from everyone supposedly knowing me and judging who they think I am, what really happened and is going to futuristically. Remember, 3 point back. Soothsaying is not a real job. To sum it up in the words of my attorney after I told her to Google me, she stated, there's a lot. That's fierce. To sum it up in the words of myself, the defendant, stated to my attorney after she stated that to me, when can I see? How much longer do I have to wait, or how many attorneys must be withdrawn for me to be included in my case and be included more than the world presently is? This is my case in every aspect. See, all of my aforementioned ongoing 5 year questions I am still waiting on for answers. Also, I want to make it known I walked out on my attorney. Also, I want to make it known I walked out on my attorney in our last meeting due to her unwarranted, uninformative, unprofessional, snotty attitude and her untruthful answers to my questions and beyond. The vicious cycle we enter every time we meet is a waste of time. And I'm saying that being in jail with supposed endless amounts of. How she treats me is extremely prejudiced, hostile, and unconcerned. She is very frustrating. One, to balk or defeat in an endeavor. Two, to induce feelings of insecurity, discouragement, or dissatisfaction. And three, to bring to nothing. So much, I presented my solution in order to coexist with and work together in a hopeful, progressive, positive, appropriate manner. I added pretend judge to I added pretend I added pretend judge to our interactions so she could calm down and ease up on her condescension, offensive demeanor, and obvious prejudgment. She seems like everyone else, not to remember. I am innocent until adjudged otherwise. She treats me as if I am not. After my introduction and explanation for with pretend judge in the room or on the phone, I am trying to help her understand how she is making herself extremely unwelcoming. When in front of a real judge and in the courtroom is how she should treat me, her client, at all times. I should not have to invent pretend judge in order to be, and am not at all wrong for wanting to be respected, no matter the outcome. I am innocent until adjudged otherwise. My attorney, everyone's should be fair, unbiased, trustworthy, honest, supportive, informative, protective, automatically and effortlessly. I should feel secure, highly confident, proud in her representing my life. I do not, and have said to her many times regarding her monumental disbelief in me and my case, which I believe contributes greatly to her inimical attitude towards me. I am hoping by this letter she will pick up the sword of injustice and fight alongside, not against me, as so many unmotivated, overwhelmed, weak attorneys prior who bowed out ungracefully and crept away from the battlefield unsuccessful. My case equals bizarre equals unknown equals different equals ignorance equals misunderstood equals unfair. This does not mean my case can't equal success, and in more than one way. While everyone continues to ring their bells of malevolence, I am ringing mine of hope, honor, plausibility, boldness. Listen, I am not a murderer. The justice system should equal fair, faith, truth, respect. Innocent until and if adjudged otherwise. 3-point back. Sarah Boone, confused cat meme. Yes, thank you. Oh my God. June 4th, 2024. Video visit, 12 minutes. In addition to my previous letter intended for hand delivery on 6/7/24 at my status hearing, today my attorney made a video visit to go over everything I've been asking for and have also sent to her personally in 2 letters, 5/20, 5/25. All on the public video visitation box, where on both sides of me, less than 5 inches away from my visit, other inmates were having their visits also. I have explained to my attorney numerous times, previously in writing and verbally, that despite the noise level, I did not in any way feel comfortable having in-depth private meetings regarding my entire criminal case on the visitation box where there is no privacy whatsoever and hold in an open bay dorm with more than 62 other interested all ears inmates. I cannot fully participate, if at all, from the entire dorm, officers included, trying to participate also in my case. As always, my attorney did not listen or care after I repeatedly tried reminding her of my unsecure environment, barking at me, I can listen or not. still going, over speaking, and not at all allowing me to respond. After repeating to her over and over and over while she's beginning to speak louder and over me still to please schedule an in-person meeting where all can be discussed further privately with no success of being heard, I disconnected telephonically. She uncooperatively. She is impossible. See previous letter or ask her for a copy of the two I sent her. I was trying to remedy or lessen before sending this to you, Your Honor, and not having to include. Now it's a race to the pulpit. My question, please, who acts like that and still be able to call themselves professional? The visitation box is primarily for family and friends to connect, and if a must from an attorney. Reminder notices, quick questions, not high-level confidential case information. She, like former attorneys who always blame their dysfunctions on me, say, you don't like the answers I give you. What answers? See pages 1, 2, and 3. I am not the problem, except that I want to and should be treated fairly, with respect, acting more professional than the paid, I've been doing this for over 40 years, professional. After so long and in all the experience, common courtesy, customer service, and listening skills should have been acquired. All attorneys, do you remember why you ever wanted to be one? Remind yourself. No one listens, and it works in everyone's favor but mine. That I am a murderer stuck in jail so they can pin on me. They're uninterested, unmotivated, hopeless. They're going to believe me over her haughty attitude. I am not wrong for not thinking less of myself because everyone else has and does. This present attorney foremost. The justice system expects me and other inmates, aka clients, to accept its subpar, nonchalant, hypocritical, next on the list attorney they keep aimlessly throwing darts for and malappointing, praying they don't withdraw. I have not fired any attorneys appointed in my case. For me expecting the highest equal standards possible, for wanting the absolute best outcome in my preposterous, mismanaged case, and representing myself is not an option, as both judges have now threatened me with for being outspoken and intelligent in all my observations of the ongoing abuse I am and have experienced. I have no new experiences from it, always being the same. Blame Boone. I refuse to be moved in wanting respect, no matter whoever everyone thinks I am. Clarity, inclusion, honesty, and professionalism. And another great reason for not having my case meetings on the public visitation box is my personal confidential inmate information, such as my visitation list 2020 to 2023 with names, etc., my interactions with inmates and officers, what I eat, when, and my personal jail calls also being thrown online. For what? To hate me more or try to get others to because I don't eat breakfast? Or because I know some Latin, have short hair, my penmanship is nice? Or because I'm not getting fat and sleeping all day, but rather fully applying myself, fighting still, making everyone upset for not having to fabricate, mutate, splice, edit? The world apparently knows all. What's next? How many times I go to the bathroom and what function I perform? No one knows anything, nor seems to want to, from being comfortable in their corruption and striving to be on top with ratings, web hits, and money. My case details, if anyone forgot, and if you think about it, all that keeps getting plastered and plagiarized, posted and poked fun at about me, it's all in my favor, proving myself right about all the mindless loomings, shoutings, the justice system advantageously abusing and profiting from everything in my cases before my trial and before I've seen. Please be sure to read my attachment for FRCP Rule 3.220E restricting disclosure? Am I the only one who thinks of these things? Why can't I win in anything? It's coming, and I'm not the problem. And if anyone were to slip on my slides and have to experience, tolerate, deal with any of what I have and am, would bravely be doing the same. Don't knock it till you try it. 3-point back. Race to the pulpit. Again, always, Sarah Boone. Oh my God. And then this is 40 other pages. Let's just see what it is. We'll start it. We're not going to finish it. West Florida Statutes, Annotated Florida Rules and Criminal Procedure 3.220. Cha, I think she just wants us to read. She just wants people to read this out. Okay. Oh, okay. I know what's going to happen now. So she wrote out the whole thing. I think it's kind of a lure and a poke fun to get people to read the whole thing. Not doing that. However, she did star what she thinks is important. So we're going to go to the beginning and we're just going to read the starred one because that's what she finds relevant. I'm guessing she didn't put a key there. She's just going to think the judge is going to know that. Okay. Discovery. Notice a discovery. B. 1. Within 15 days after service of the notice of discovery, the prosecutor shall serve a written discovery exhibit which shall disclose to the defendant and permit the defendant to expect, copy, test, and photograph the following information and material within the state's possession or control. Okay, next one is H. Whether there has been any electronic surveillance, including wiretapping, of the premise of the defendant or the conversations of which the defendant was a party and any documents relating thereto. Okay, so I think that means she wants, does she want the interrogation? I think she wants the videos off her phone, which I'm like, that's not going to really help you. I cannot imagine that the lawyer does not have the videos. What is Sarah going to do with them? Whatever. Maybe she thought they bugged her or something. Okay. D, defendant's obligation. If a defendant elects to participate in discovery, either through filing the appropriate notice or by participating in any discovery process, including the taking of a discovery deposition, the following disclosures shall be made. A, within 15 days after receipt by the defendant of the discovery exhibit furnished by the prosecutor, pursuant to subdivision B1A of this rule, the defendant shall furnish to the prosecution a written list of the names and addresses of all witnesses whom the defendant expects to call as witnesses at the trial or hearing. When the prosecutor subpoenas a witness whose name has been furnished by the defendant except for the trial subpoenas, the rules applicable to the taking of depositions shall apply. The rules applicable to the taking of depositions shall apply. B, within 15 days after receipt of the prosecution's discovery exhibit, the defendant shall serve a written discovery exhibit which shall disclose to and permit the prosecutor to inspect, copy, test, photograph the following information and material that is in the defendant's possession or control. II2. The prosecutor and defendant shall perform their obligations under this rule in a manner mutually agreeable as ordered by the court. 3. The filing of a motion for protective order by the prosecutor will automatically stay the times provided for in this subdivision. If a protective order is granted, the defendant may, within 2 days thereafter, or at any time before the prosecutor furnishes the information or material that is subject to the motion for protective order, withdraw the defendant's notice of discovery and not be required to furnish reciprocal discovery. Okay, so she wants a protective order over stuff being released online. Restricting disclosure. The court on its own initiative or on motion of counsel should deny or partially restrict disclosures authorized by this rule, find it if it finds there is a substantial risk to any person of physical harm, intimidation, bribery, economic reprisals, or unnecessary annoyance or embarrassment resulting from the disclosure that outweighs any usefulness of the disclosure to either party. She said, keep my details, keep my name out your mouth. No. I'm guessing she thinks her information being out there does all of these things. I don't think so. Let's see, what is the rest of this? She's just writing more stuff. Okay. Stars. uh, okay, she's going through definitions. I am sorry about that. That may have been loud, but she is looking at the Florida Constitution 2024. She wants to remind the court and the world what these definitions are. So let's get into it. In case you didn't know, a client is a person who relies on the professional services of another. The client of an attorney is the person or entity represented and advised by the attorney. A client relationship commences for an attorney with an agreement with the performance of service in reliance on a request or representation or with a statement of representation on which the client relies. So that's who Sarah Boone is. She's also a defendant in a murder trial, but we can say client to be nice. Attorney-client privilege, one of the oldest recognized privileges for honest, equitable, confidential communications intended to encourage open, full, and frank communication between attorneys. Some of this wording is a little suspect to me. But I'm not going to say, I'm not going to I am going to believe that she wrote this correctly, but full and frank, I guess that is Florida verbiage. Full and frank communication between attorneys and their clients, thereby promoting broader, confident correspondence in accordance to the appropriate observance of law and the administration of justice. Zealous advocacy. Oh, this one has two definitions. Zealous advocacy. An attorney must represent each client to the fullest extent under the law and requires representation to the attorney's fullest abilities without violating the rules of professional responsibility. It requires not only presenting each argument required by a client to every institution in which that client has business, but also framing each argument in the strongest terms of law that greatly benefit the client while remaining faithful to the facts and to follow the law itself. She did not read that paragraph herself because it says strongest in terms of law. That's what they've been doing. They've been telling you go for the battered spouse defense. They've been telling you go for the I was drunk. This is involuntary manslaughter. You want to go with the case you want, and that is not the strongest legal frame. So they are doing you a disservice. They are not being zealous advocates by getting up there and saying what you just want them to say. Being a zealous advocate is doing whatever they think they can do to get you either acquitted, not guilty, or a plea deal or something, your best outcome. You have that misconstrued. Here is the thing that you need to highlight. In the strongest terms of law that greatly benefit the client, they have to look out for what benefits you. You telling your story benefits you what? Emotionally? It does not benefit you legally. And it also says while remaining faithful to the facts and the law itself. The facts are you killed this man when you zipped him up in a suitcase, filmed him, laughed at him, walked away, and went to bed. Those are the facts of the case. She wants to distance herself from those facts as much as possible, and that is a want and a hope and a dream that she can have, but the facts are the facts. It's a video you took your voice on your phone that you voluntarily handed to the police. You specifically told them to search your phone because you said it had evidence that showed how abusive George was to you, not realizing that it also had the evidence of you being a malicious, horrible human being to another person who is begging for their life. Zealous advocacy is not doing what you want. Zealous advocacy is a requirement of the oaths required by attorneys admitted to the success of the adversary system of justice. Disruptive, disrespectful, degrading, or any disparaging rhetoric is never an inclusion of zealous advocacy, and the use of such crosses the line from acceptable, forceful advocacy into unethical conduct. Beauvair Law Library 2012 edition. Now, here's the thing. She thinks that saying the disruptive, disrespectful, degrading, or disparaging rhetoric is not zealous advocacy. She's trying to say that's the treatment that she's been receiving. But she's the one who's been disruptive, disrespectful, and degrading. She even said, in my first meeting with Miss Cashman, I told her that her snotty attitude is unwarranted. That is disruptive to the process, disrespectful, and degrading. Who are you to come to me, Miss Cashman, your eighth attorney, after 7 people have gone missing from this case? And the first thing you said is my snotty attitude. Girl, I would have snatched you from across the table if I was Miss Cashman. But she is a real professional who is, for 40 years, been concentrated on zealous advocacy. Even if that means the client is upset, that is her job, to put on the best case for you. But she's not there to put on a case for you, meaning I'm going to do this representing you, but I'm not here to tell the story that you want to tell. I'm here to tell the best story that can help you. Okay, I'm rambling. Where are we? We are 31 pages in. See, this isn't too bad once you just read the stars. Attorney misconduct. Girl, she trying it. She is trying it. Oh no. She put the whole thing in there. Okay. Let's see what what she learned from attorney misconduct. Attorney misconduct is a failure of an attorney to comply to Attorney misconduct is a failure of an attorney to comport with the rules and accepted professional customs of the bar, and includes any act or omission of duty by an attorney that fails to perform appropriately the office of an attorney as an officer of the court, as a counselor and fiduciary of a client, as a counselor and fiduciary of a client, or as a member of the legal profession. The scope of attorney misconduct reaches also to conduct of attorneys that is harmful to the appropriate reliance of the citizen upon the law and legal profession. Citizenry. Okay. The scope of attorney misconduct reaches also to the conduct of attorney that is harmful to the appropriate reliance of the citizenry upon the law and legal profession. Attorney misconduct includes actions or omissions that enable others to cause harm, not just harm caused directly by the attorney, and not all misconduct is subject to remedy or to sanctions, although a variety of forms of each exist. Misconduct may always be the basis Misconduct may always be the basis for a client to remove an attorney from their duty of representation, as is any other cause or the client's loss of trust and confidence in a lawyer. And the attorney's demeanor to determine dot 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 and the attorney's demeanor to determine whether a party's substantial rights were affected, based on repeated or persistent objected to misconduct, the district court shall factor into its analysis that the notice, by engaging in continual misconduct, the offending attorney has accepted the risk of the client's case may be said influenced by said misconduct. Therefore, the district court shall give great weight to the fact that single instances of improper conduct that could have been cured by objection and admonishment might not be curable when that improper conduct is repeated or persistent. Okay. I guess she believes this is what she's facing. Cool, girl. Duress, an unlawful threat that limits the person's independence of judgment or action, and is any improper threat or condition, such as coercion, that limits a person's ability to think or act independently, and the presence of destroys the independence required of the party subject to. In order to constitute a voluntary consent, it must be, it must clearly it must clearly appear that the search was voluntarily permitted or expressively invited and agreed to by the person whose right is involved. In addition, such person must be cognizant of their rights in the premise. The consent need not be contaminated by any duress or coercion, and the government has the burden of proof. Okay. So she's saying I'm guessing she's saying she gave her phone under duress, and that that was infringing on her constitutional rights because they didn't let her know of her rights when she handed her phone over, I guess is what she's trying to say. And consent must not be contaminated by any duress or coercion. So she's also arguing that at the time she's under duress and that the two officers were being coercive. Okay. Oh my gosh. Habeas corpus. Girl. A review of the lawfulness of any person's custody or restraint by a government official. It is a process of judicial review of any person's detention, whether by dorm, I don't know, today, incarceration, or continuing restraint by an official or agent of the government of a state or the federal government. Gosh. The right to review custody by habeas corpus is a fundamental constitutional right. It is a bulwark of individual liberty being used to free people by courts without legal authority or without having complied with requirements of laws. Habeas corpus is protected in the United States Constitution from interference. So I guess she's saying that she's being unlawfully held there. It's been so long and no one's giving her bail. So they're going against habeas corpus by not trying to get her a bail offer. And so, like, she shouldn't be staying there. And that her custody is unlawful. Oh, and then the star here. Okay. A defendant who has been confined for 30 days after their arrest without a trial shall be allowed a preliminary hearing upon application. Yes, girl, go ahead and remove this star. You waived the right to a speedy trial whoa, years longs ago. This does not apply to you. That is what due process means. Of if you were in there for 30 days, you at least need to be a hearing. You have a right to a speedy trial. You waived that right. So you will sit there as long as it takes for you to calm down, act correct, and get this trial over with. Informal consent. Oh my gosh, I think this is the first edit we've seen. I'm surprised she didn't just start over and like rewrite the whole page. Informal consent. Consent given with appropriate knowledge after the person giving consent has learned all the information that would be reasonably required for the basis of a reasonable decision. In many instances, for an institution or professional to prove that the decision maker was sufficiently informed over a matter to give informed consent, the institution or professional will provide the information requisite to making such a decision in an informed way. But the production of this information is not a legal requirement to receive informed consent unless a custom statute or regulation requires it. So what else is she saying? An attorney or other professional has an obligation to provide any person with adequate information or explanation of the proposed course of action and its alternatives for the person to know of the material risk of each before consenting. By definition, professionals and fiduciaries have similar obligations to their clients and to those with a reasonable right to rely on their information or advice before consenting. The lawyer or other professional shall, one, promptly inform the client of any decision or circumstance with respect to which the client's informed consent as defined in Rule 10E is required. Okay, so she's saying that even though she whatever gave consent, she didn't give informed consent because no one made her fully aware to her standards of what was actually happening. And I'm guessing she's thinking that if I was formally informed properly, I would not have given consent. And thus, all the information that was acquired from that unlawful search should be thrown out. She's trying to get the video thrown out of her case. Not going to happen. So yeah, she's just trying to say that even though I voluntarily handed over my phone, and she's even like not this is borderline brags about it in the interrogation that she handed over her phone and to go ahead and go through it and that there's nothing's wrong. Now she's saying that she did not give consent for that. So whatever is in that phone, whatever you found, was taken unlawfully, and if it's unlawfully taken, it should be thrown out of the case. Nice try. Legal ethics. Page 35. Oh my gosh. Okay. This is a lot. Oh no, there's maps. There's maps. No. Whoa. What is this? Publicity, expectation, and saturation. What is going on here? Why are there stars? There's stars all over the place. What is happening here? There's stars all over the world. I'm guessing is she saying, are these stars like where she's received mail from and that it's been this widespread and is corrupt? Oh my gosh. Uh I need to get to this map. I'm sorry, I have to stop where I was. Where was I? Where was I? We're at legal ethics. How far am I until the maps? That is so much. Okay, I'm just going to try to blitz through this, and if I get too much, I'm just going to quit and getting to the maps because these maps. Interrogation, examination of a suspect. Oh, okay. I do want to get into this one. Here we go. Custodial interrogation. Let's get into this. What does she think she had? Interrogation, examination of a suspect. The process of inquiry by which police and or other law enforcement personnel seek information from a person suspect of a crime. Interrogation is distinct from interview, as titled on my transcripts. They are they are used interchangeably. It is used, what you had is an interview. All interrogations are called interviews. It's like squares versus rectangles. All interrogations are interviews, but not all interviews are interrogations. So they just call it interview. Interrogation is distinct from interview as titled on my transcripts, in that the police seek not merely information in general from the suspect, but also statements from the suspect that are either directly or indirectly incriminating. This may involve direct questioning or other actions designed ultimately to elicit such an incrimination and is subject to the due process of law without any compliance. Sorry. Um, but yes, they had you in as it started as an interview. Also, interviews can move into interrogations. They're not, you don't have to say, oh, we have to stop this interview so we can call you back in for an interrogation. It started as an interview. They just wanted information from you. Uh, they didn't need it. They had the video. You were already incriminated. So that moved into, let's just get some statements. You're not going to give us a true answer. So let's just get you to admit this, or just to get you to dig a hole. Just because you said incriminating things, they stopped talking. Oh my gosh, I almost forgot this. They stopped talking for so long, and she just kept asking questions. That was her reinitiating the interrogation every single time. There was nothing unlawful about that. They stopped asking you questions. And when you reinitiate it, they are allowed to ask reciprocal questions. Then they stop talking again. You ask more questions. You could not stop talking. They told you about your rights up front. You had the right to remain silent. You ignored them. You were formally informed. How do we know? Because it's all recorded. Compulsion. The word is compulsion. Is subject to the due process of law without any compulsion of any kind. Got it. Interrogation, as conceptualized in the Miranda sense, reflects a measure of compulsion above and beyond that inherent in custody itself, referring not only to express questioning, but also to any words or actions on the part of the police other than those normally attendant to arrest and custody that the police should know are reasonably likely to elicit an incriminating response from the suspect. Yeah, you didn't have any of that. They just asked you questions. Those type of actions you're talking about, that's like, oh, do you want a meal from McDonald's? We'll give you this. If you do you want something to drink? Do you want this? That's them doing purposeful actions to get you to, be more willing to talk to them. And then they might have, other tactics to elicit other more specific responses. But that's what that's talking about. No one used any of those tactics. I think she's thinking her being cornered in that room is a tactic, but that's just kind of standard for all of them, even though that is technically a tactic. So custodial interrogation. Interrogation of a person in the custody of law enforcement officials and is following a person's arrest or custody. The hallmark of custodial interrogation is the person knows that the person is in custody and has no freedom to leave. I did not know. I was in custody and could not leave. I was told by Kipsy, I think that's the woman, to come pick up my phone. No warning of being interrogated again. Something custodial interrogation, the stakes of interrogation are higher than when a person is free to go. And any statement made in custody during the present is presented to be coerced under the Fifth Amendment. Let's back up. First of all, the police can lie to lure you down to the station. They can do that. They can say, oh, I just had one paper that I need you to sign, or you left something here. Can you come here? They could trick you in any myriad ways. And once you're in that parking lot, they can arrest you there. So her saying, would you like to come pick up your phone? They didn't force you there. You went there voluntarily. Was it a trick? Was it slightly deceitful? Yeah, absolutely. They were going to arrest you anyway. They were going to find you and they were going to put handcuffs on you. You just saved them that by coming down there voluntarily yourself. However, whenever you are with police officers, you're basically in their custody, right? You're in a police station, you're in custody. Custody does not mean under arrest. However, custody plus Miranda equals interrogation. So maybe this was an interrogation from the start. Interview, interrogation. It started as an interview, what have you. But once they had that video, she was going to get arrested one way or the other. So custody, you're in the interrogation room. They did not tell you you're free to go. They will normally tell you before they read you your rights. They'll be like, this is, an interview. You're free to go. If they do not say you're free to go, you are under arrest, because you don't have to talk to them. You could just say, I choose to remain silent and you don't want to have this interview. And they're like, okay, cool. Stand up. You're under arrest. So regardless of whether or not she did the interrogation, she would have been arrested that day. So I did not know I was in custody and could not leave. I was told by Kipsu to come pick up my phone. No warning of being interrogated again. Why would anyone warn you about an interrogation? Because then you would just come up with any answers. But that is really funny that she just doesn't know that anytime you're with police like that, you're in their custody. They took you to an interview room. Even if you're innocent, if you are in an interview room in a police station, you are in police custody. It's not like a bad thing. It's just a thing. All right. Sorry. Got so excited there. Excited utterance. No, stop. Stop. Not excited utterance. Let's read the definition, then we'll go. Spontaneous declaration or spontaneous exclamation. An unthinking statement made at a moment of great surprise and stress. An excited utterance is a statement made during or immediately after the declarant is surprised by a startling event or condition, while the declarant is under the stress or excitement caused by the event or condition. She's trying to say anything she said in there that was incriminating was an excited utterance. Was it an excited utterance all 140 plus times you said not intentional? Were those all excited utterances? Not intentional, not intentional. An excited utterance, I think the best example is the most recent, this Karen Reed trial. They're trying to stretch and say, her saying, did I hit him? Could I have hit him? And now they're warping or whatever. And they're saying, she said, I hit him, I hit him, I hit him, right after she found him and like went into a humongous catatonic breakdown. That would be an exciting utterance. You are surprised by something, a lot of high emotions, you say things. If you're in an interrogation and the police have been screaming at you and like slam something on the table and you just scream, I killed them. That could be an that can be an excited utterance because it was brought on by startling or surprising events. What else was surprising in that interrogation? They were pretty calm the whole time until they showed that video. Okay, I'm sorry. We're back to the maps. I I will not get over this. I'm going to sleep. I'm going to dream about these maps. These stars, what do they mean? Okay. Public publicity, exploitation, and saturation. United States United States map, page 1. To date, each star is a state where I have received I knew it. I knew it. Is a correspondence via mail or message regarding my current criminal case. World map, page 2. To date, each star is a continent where I have received correspondence via mail or message regarding my criminal case. The number grows daily. Girl, we're all connected now online. They're not sending a carrier pigeon. This is not the serve you think it is. We all get texts from people from different states around the world. It doesn't mean that our whole business is out there for everyone in those places. But let's count them up. She got 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14, 15, 16, 17, 18, 19, 20, 21, 22, 23, 24. She's gotten 24 states. And you know what? I know she's actually mad that there's not more. You know she actually wants more. And then the continents, North America. Okay, well, Canada and America are both in the same continent, but sure, one continent, two continents, and then 3 for Asia. Okay, 3 continents. Most all letters and messages are available for review and understanding of the impact of my case details being made readily available on the global internet, creating wrongful ignorance, hate, and massive prejudice before my trial. Does she not get everyone's information is available? Florida has some of the strongest or weakest, no, strongest sunshine laws there is. They want a transparent system. What is the phrase? Sunshine is the best disinfectant. Allowing people to see this allows us to keep everyone accountable. When the government can't hide stuff, we can't say that things are going wrong, or at least we know when things are amuck. I mean, back to the Karen Reed trial. If we didn't have this kind of sunshine public right to a public trial, then the police could have easily just kept that covered up. Without cameras in there showing the entire world everything, they easily could have put pressure on the jury, I think. Anyway, made readily available on the global internet, creating wrongful ignorance, hate, and massive prejudgment before my trial. I, the defendant in my case, have not yet, ongoing 5 years, fully reviewed or even seen all of my case details. Everyone in the world has already had the opportunity to do so themselves. Why don't you have them send it to you then? If the whole world has it and you have fans everywhere who will start GoFundMe's to pay your bond and you got correspondences from South Korea, why can you not just get them to send you the information? Are they against you too? Do they not want you to know? Child. Or are you just making shit up? The continuation of the obvious exploitation allows the world to keep pressing their incorrect, presumed unfair theories, ideas, accusations, forcibly insinuating I committed criminal acts. She wants so bad to not be called a murderer because she doesn't see herself as one. And I get that because, you know, in her mind, she thinks murderers are people who want to end someone's life. She didn't want to end his life, and I believe that. Um, I truly believe because she's like, I'm this straight A student. I know what was better for him. I knew him better than he knew himself. Well, if you knew him better, why didn't you know that he was being serious when he said he couldn't breathe? Because you're full of shit about everything. But this is her. I truly believe that she did not think George was going to die in that suitcase overnight. Um, I believe she knew it was cruel. I believe she knew she was causing him immense pain and embarrassment and humiliation in his last moments. But I think that she thought, oh, after all the things you've done to me, I've been hurt. I felt like this. You can take a little nap in there, and then I'll let you out in the morning, and then you better behave better, or what have you. And that in her mind, her drunk, out of her mind state, which is why that would have been the better defense to go with. Um, her drunk state is that he's not going to die from this. And he did. And now she doesn't want to be called a murderer because she never had murderous intentions and doesn't see herself as that. Facts are the facts. My present attorney said it is not necessary to receive a court order. I've been trying to obtain to download my case information to apply OCCD tablets. What? My former attorneys are withholding some of my case contents I have supplied to them and which have been deemed lost. Many other items have been returned, not to myself, but to the next attorney, and which have been unable to be located to date. Yeah, they're not going to say you get a new lawyer, so they're going to give you all of their stuff every time, because then you're just going to lose it. Or you're going to be upset that you got it and be like, I don't know what I'm supposed to do with all this. How did I know I was supposed to keep all these? That's why they hand it off to each other, to make sure everything's there. Oh my gosh. She thinks she knows so much. And it's that attitude that reveals how little she actually does know. And it's disappointing. I am missing innumerable case items, which I continuously request to be returned or obtained without success. She also never details any of this stuff. You could give a general sense of something without giving the details. Attorney number 6 was supplied with something in a package on X date, since you have everything marked down, and I have not received that return. Or I had some important notes or files that were given to X, Y, and Z, and it was this kind of, but no, it's just I gave them things and they're lost. All these things people can just say, nothing proven. So annoying. Invasion of privacy. Supreme Court wrongful conduct. Defame. Grrr, not you saying, trying to bring out defamation, but let's talk about it. Defame. To injure or destroy the reputation of by libel or slander. Anything is defamatory if it, quote, has the tendency to render the party about whom it is published contemptible or ridiculous in public estimation, or expose them to public hatred or contempt, or hinder virtuous men from associating with him. An opinion can be actionable if it implies the allegation of undisclosed defamatory facts as the basis for the opinion. Okay, let's talk about defamation and why it can't apply to Sarah Boone. One, the absolute defense to defamation is truth. So if what people are saying is the truth, then it's not defamatory. If people are calling you a murderer and you ended someone's life, that is not defamatory. Also, girl, what if it is? Are you going to sue everyone who calls you a murderer? With what money? You can't afford this 8th, 9th attorney. So people are good. They're fine. Defamation, your reputation has to be ruined, and your reputation, and it has to be ruined by the defamatory defamatory comments, meaning you can't just pick out one person who's calling you a murderer if everyone's calling you a murderer. You have to show this one person's specific statements caused individual harm, unless you want to try to sue everyone. It's also not defamatory if your reputation cannot be defamed. So like people like Jeffree Star, maybe James Charles, uh, Trisha Paytas. Those are just some mild cases of people who can't be defamed because their reputation has already been drug and through the dirt so many times. And Shane Dawson, anything that has been said about them has pretty much already been said, so they can't really be defamed, which kind of sucks. But you know, the truth is the truth. You have to be able to pinpoint that those statements, those defamatory statements specifically caused you harm in some way. And you have to be able to show and prove that it did cause you harm. You have become a public figure now, especially by your own admittal. Public figure status is not always consensual, so you didn't choose to be that, but you are, meaning that you also have the hurdle of actual malice to prove. Actual malice does not mean you had malicious intent when making the defamatory statements. It means that you had a 100% knowing of the truth when you made those false statements, or a reckless disregard for the truth when making those statements. And actual malice is really hard to prove because how can you prove that I don't believe what I thought? If I said that Ted Cruz is the Zodiac killer, how can you prove that I do not believe that to the depths of my soul? Because I believe that to the depths of my soul. Which is hard. So it's very hard to prove unless the person, like in the Cardi B, Tasha K court case, where she admitted, yes, I knew this was false, and yes, I said these things in order to harm her. That's how she won that, because she admits to knowing the truth. Or in the Johnny Depp Amber Heard case, relationships are really easy for actual malice because you both were there. Either it happened or it did not happen. So regardless, you both know what the actual truth is. So actual malice is easy to prove in one-on-one relationships, but parasocial relationships online, how do you prove someone does not believe that Sarah Boone is a bleach blonde, bad built, butch body murderer? You can't. So anyway, that's your little crash course in defamation. Oh my God. Invasion of privacy, false light. Where are these stars? Another star. Publicity, exploitation, and saturation. I don't care. Okay. This page seems relevant. My personal individual criminal case is being advantageously exploited and abused from all of my significant life-saving suppressible case details, evidence, proof being illegally obtained by coercion, trickery, duress, confusion, and without my permission in any form, written or verbal, to anyone, then broadcasted, distributed, hand-delivered to the entire planet, states, countries, continents, species, aliens, orangutans, containing all of my potential jurors, causing irreparable, erroneous falseness, greatly tainting my jury pool altogether by forcibly attributing heavily influenced, incorrect, inappropriate motives, theories, ideas. She thinks she is way more important than she is. I promise you, there are plenty of people where you live that know nothing about you. I try to tell my parents about this case. They forget your name every time I bring it up. I and in Florida, Florida is insane with the cases there. People are not pressed about you. Finding a jury is not going to be that hard, I can guarantee. But she keeps doing stuff like this because she wants to wrap up or rack up more support, more buzz, more talk, because she wants more leverage in an appeal, because she knows she's going to lose. She wants leverage in an appeal that her case was contaminated, that she never had a lawyer that was actually trying to help her, that the judge were against her, everyone was against her, all of her rights were being stomped on. And yada yada yada. So let me go because it's all unfair. Me. Everyone's unfair to me. And also, she keeps saying, it's my case, it's my case, it's my case. It's not your case. Let's be 100% clear on that. You are on trial, but this is the case of the murder of Jose Torres, who goes by George Torres. That is whose case this is. You are on trial as the murder suspect and defendant. This is not the case of Sarah Boone. This is the trial of Sarah Boone, suspected murderer in the Jose Torres case. And I don't really want people to forget that. So get all of the attention you want now. Make it all about you, all you want. But at the end of the day, this trial will happen. Justice for George will be had. Whether he was a flawed, abusive individual himself or not, no one deserves what happened to him. And I can't imagine the last things you hear from the person that you allegedly love are taunts and insults and them laughing at you while you're dying. Which also, another thing that's also been annoying to me is that he was also incredibly drunk and locked in this suitcase. Is she saying that she left a hole in there for him to get out? I know that's not true, but let's just say it is true. How is he supposed to figure that out when he's disoriented? Allegedly was thrown down the flight of stairs, says the roommates that could hear it from the other side. They heard a really big crash coming from the top of the stairs to the bottom of the stairs. He's disoriented, probably doesn't know which side from up, drunk, can barely focus on breath, and now you're saying he should have just been able, you've been opening with one finger. That was one of the most disrespectful comments to me. She kept saying, I could open it with one finger. I could open it with one finger, as though to insult his intelligence or capabilities, that if I could do it with one finger, he should have been able to save his own life. Terrible. This obvious exploitation and invasion of my privacy is creating unnecessary, unlawful oppression, depleting all of my entitled opportunities to be given a fair, proper, successful conclusion to my case. You have been given fair and proper process, and this will be a successful conclusion to your case when you are locked away forever. Because another thing that she doesn't get is this judge is the one who will be sentencing you. So every time you accuse him of being advantageous or abusive or corrupt or profiting off of these things, he is seeing this. He is seeing that this is who you are. These are the behaviors. Should you really be allowed back in the public? After 5 years after you zipped your boyfriend up into a suitcase, your behavior has not changed at all. You have taken no accountability. You refer to him as the decedent in former proceedings, which was just so insulting. You didn't care about him, at least not in the way that you're saying you did. And you're making yourself the victim. Even to this day, you have no compassion for him. You take no responsibility for any of your own behaviors. Everything is happening to you. Me. People are doing this to me. Why are people so mean to me? Why are people doing this? Why is no one treating me nice? Because you murdered someone. Niceness is off the table. Niceness is out of the room. Niceness is not in the room with us right now. Just like niceness was not in the room when you left him locked in a suitcase. So get over it. No one has the obligation to be nice to you. They have the obligation to zealously advocate on your behalf, to give you a fair trial, but nobody has to be nice to you. A misprejudgment has already been made unfairly against me from the undeniable violations of my constitutional rights and due process as a result of my entire case and personal life being publicized globally before my rightful trial, which lawfully, ethically should be without disadvantage and freedom of all partiality, deceitfulness, and dishonesty made from said evident exploitation. Definitions collected from, not her citing her sources, it's not APA style, but she tried. Not Smart Communications tablet. The Law Library, Merriam-Webster's Dictionary, tablet. So exploit, exploitation, abuse, significant, suppress, illegal, coerce, trickery, not trickery. So this is just everything that she defined in here. Yeah, we're not reading this. Okay, I think these are all just definitions. Coercion, Freedom of Information Act. Oh, so you do know the Freedom of Information Act? Ah! So you know the Freedom of Information Act, and you are questioning why all of your case details are up there. Okay, you said not the 9 categories of government information exempt from Freedom of Information Acts are. Okay, so she's saying, yes, I know about it, but number 7, law enforcement records, if the production could reasonably be expected to interfere with enforcement proceedings to deprive a person of a right to a fair trial or an impartial adjudication, to constitute an unwarranted invasion of personal privacy, to endanger the life or physical safety of an individual. The reason why this doesn't apply, because no one forced her to write any of these letters. She is writing these letters with the known fact that these details in this letter will be scanned online and will be posted. So if she didn't post these things, we wouldn't know half the stuff we do know. And the sleuthing that people find from, courthouse records or whatever, those are not just your records. People can look up records for anyone, more or less. These being online do not interfere with the enforcement proceedings. The courts are going along just fine. The only issue is that you won't stick with the lawyer. Everyone else says they could wrap this up in 5 days, and it will be wrapped up in a week. Karen Reed's trial has gone 9 weeks. This will go on, they said, 5 days. Y'all are not the same. And that's it, y'all. That is the entire 58-page letter of Miss Boone. And I'm glad I didn't read all that stuff. The stars were the most important part. Yeah, if you have any thoughts or opinions, leave them in the comments. Like, subscribe if you like this, or dislike, whatever you're feeling. Yeah, this case is wild.
So I don't know what I'm doing wrong other than wanting to have a very successful outcome. It's just been long and drawn out, and I'm doing my best to let everyone know who I really am, as opposed to the malicious murderer that everyone thinks that I am.